Good afternoon, good evening, and welcome to our webinar on the recent Supreme Court judgment in the DMRC versus DAMEPL case and its impact on arbitration seated in India. It is my pleasure to introduce our panelists who bring a wealth of experience and expertise and diverse perspectives to this discussion. First, we have Ms. Mehak Oberoi. She is the legal head at GE Vernova Hydropower, APAC. With over 16 years of distinguished tenure, Ms. Oberoi has mastered the art of orchestrating legal strategies in the dynamic renewable sector. As a lawyer and trained mediator, she successfully navigates intricate legal landscapes and seamlessly fuses business objectives with compliance mandates and ensures operational fluidity and strategic alignment. Beyond legal realms, she champions diversity and women empowerment initiatives, notably being a founding member of the Global Renewables Women's Network. Her accolades include legal awards for multi-million-dollar negotiations and resolving complex disputes, underscoring her commitment to driving sustainable growth and organizational excellence. Next, we have Ms. Uma Menon, a construction and engineering expert with over 23 years of experience in various projects across Singapore, Asia Pacific, India, and the Middle East. Uma's expertise covers an assessment of delay, forensic planning, contractual and quantum matters. She defends and settles claims and advises on a lot of matters related to dispute resolutions. She has been appointed as an independent expert to provide opinions in several arbitrations and adjudications. She is a practicing member of the Academy of Experts and a fellow of the Chartered Institute of Arbitrators. We also have the pleasure of welcoming Mr. AKS Chauhan, the President and Head for Contracts and Management at GR Infraprojects Ltd, with a bachelor's degree in civil engineering and over 43 years of experience in the field. Mr. Chauhan has worked with both public and private sector organizations. He holds various memberships, including the Indian Roads Congress, the All India Management Association, the Indian Institute of Technical Arbitrators, and the Chartered Institute of Arbitrators, London. Mr. Chauhan has been appointed as an arbitrator on the panel of the Construction Industry Arbitration Council and is responsible for overseeing the contracts management and disputes resolution at GR Infraprojects Limited. Last but not the least, we have Ms. Hannah Fry, a barrister with the domestic and international practice, specializing in commercial, company, and insolvency matters. Hannah frequently appears in the Supreme Court of England and Wales, Privy Council, and various divisions of the High Court, both as a junior and sole counsel. She has extensive experience in international arbitrations under various rules, including ICC, LCIA, ADCAC, and UNCITRAL. Prior to joining the bar, Hannah obtained a first-class law degree and a distinction in her Masters of Law in Comparative and International Dispute Resolution from Queen Mary, University of London. My name is Adarsh Ramakrishnan. I'm a partner at MRP Advisory, Dubai, where we advise and represent companies in disputes all over the world. I will be moderating this discussion and having an unenviable role of attempting equal speaking time for all our panelists and identifying questions from our audience. With such an esteemed panel, I'm confident that we'll have an engaging and insightful discussion on the implications of this judgment and its impact on arbitrations in India. Let us begin by exploring the key legal principles highlighted in this landmark ruling and how they will shape the future of arbitration practice in this country. My first question is to Mehak. I want to understand more from her from how she would be strategizing in relation to what would be the arbitration landscape in India. Mehak, what strategies can parties now employ to effectively utilize negotiation and mediation in dispute resolution proceedings? I know you're a trained mediator, and considering the Supreme Court has given some guidance on the importance of giving full effect to the terms of the contract and respecting contractual intent, how do you think you'll be able to strategize for parties? Sorry, Mehak, you're on mute.
I'm sorry. So I think it has two aspects, negotiation and mediation. So let's talk about negotiation first. Parties need to always understand that contracts are made for a rainy day. You're going to open that contract and decide your fate only when there is a claim at hand or there is an issue at hand, right? So it needs to be properly drafted. One. Two, when you're you need to document everything And when I mean that during even the negotiation phase, it's very important that even the discussions or meetings leading up to your final contract clause should be documented, because that a lot of the times will be used by the tribunal, by the mediator, by the parties to understand what the intent was initially. And of course, negotiation, again, when you enter a negotiation room, please understand it has to be a collaborative negotiation. We're looking for a win-win situation. We're looking to be completely prepared. We need to understand what our must-haves are, ideally haves are, and what are our trade-offs. So that's where the parties need to be able to understand what they need to do on a negotiation front. As far as mediation is concerned, I think the Mediation Act has already sorted a lot of questions for us. But again, I think what we need to introduce in our contracts is either med-arb clauses or arb-med-arb clauses, especially in big projects like we are doing. It's the project duration is so long. Every single day of delay is depleting my cost margin, my contract margin. So you can't have mediation in isolation. You can't have arbitration in isolation. You have to club both of them. So that's very important. You need trained mediators also. You need domain-specific mediators to be able to help in facilitating a resolution for the dispute as well. So I think, yeah, and institutional mediation, of course. Ad hoc mediation is not something that's going to work. We've seen that with arbitration also. So I think ad hoc mediation also can't. So, yeah.
Thank you, Mehak. My next question goes out to Uma. Uma, we've seen that this arbitral tribunal composed of the so-called technical arbitrators who are usually retired engineers or public civil servants. A lot of these people are also entering the realm of providing claims consultancy services or expert witness services. Do you see this judgment impacting the role of expert witnesses in arbitration, particularly in assessment of evidence? I'm conscious that this arbitration did not have expert evidence, particularly in the realm of in the fields that you specialize in.
Thank you, Adarsh. Yes, if I am to talk about the role of the expert, especially in view of this topic, yes, it is important. It is very important because the construction disputes are invariably very complex. The nature of the disputes are very complex, and there are several aspects to it. So, as you can see, an expert evidence would only help the tribunal or the arbitrator or the judge. And it is important that parties understand the significance of expert evidence, how it assists the tribunal. And from what I understand, Indian case law is also quite supportive of expert evidence. If I remember, there is a Simplex infrastructure case where the Supreme Court has emphasized the significance of expert evidence, and there are some other cases with NHAI. So I think it is important, and they do recognize and appreciate that the experts bring the tribunal to see what they have to see. You know, they take them there. The route is provided by the experts because that is their expertise, which helps them to come to an informed decision. So in that sense, I feel that there are several areas in construction disputes which require specialist evidence, opinion, which the legal teams would not have, the tribunal would not have. So, and there are many aspects which need to be considered. As in this case, the one that we are talking about today, there are defects. And they were not, what is the severity of those defects? Were there effective steps taken? These are really questions for a technical expert who would have given, very valuable evidence which the tribunal could take on board. And the chances of such an award getting challenged is much lesser because it has got this backup with the expert evidence. supporting it, and whatever decision the tribunal comes to based on that. So I think the role of the experts would become more significant in light of this judgment, because especially in disputes where there are complex areas, I think the parties would and the legal teams would recognize the significance of having the experts on board.
Certainly, Uma. Yes, I certainly take your comment on board about how experts could have potentially been used in this arbitration. Of course, we're all looking at hindsight here. My next question goes to Hannah. Hannah, before I ask you the question, there are some interesting stats that I just felt like we should be looking at. There is a website organized by the Department of Economic Affairs called PPP in India. I mean, several of these public-private partnerships have already been created. There are 220 entries on the website where PPPs are already ongoing in India, and there are 358 in consideration. A lot of these PPP models involve foreign funded or non-Indian, at least from an Indian perspective, foreign funded funds. Now, from an international perspective, given that there are going to be so many other private entities that are going to be investing in India, how do you foresee this judgment influencing the approach of these foreign companies engaging in arbitration seated in India?
Thank you, Adarsh and MRP Advisory for having me on this panel today. From one perspective, the judgment may have a potential chilling effect in influencing foreign entities to engage in arbitration seated in India for two reasons. First, because of the degree and extent of judicial interventionism of the arbitral award in the judgment. So as we've seen, the Supreme Court effectively re-examined the interpretation of the terms of the contract and also reappreciated the evidence on record, which ordinarily are in the domain of the tribunal. And arguably that could be contrary to the principles of minimal judicial intervention as enshrined in Section 5 of India's Arbitration Act. However, the other argument could be that the use of the curative petition could open floodgates and undermine the doctrine of finality. The Supreme Court here set aside an arbitration award which was made after 68 hearings and after consideration of 35,000 pages of documents and oral evidence, 7 years after the award was passed. The curative petition before the Supreme Court was the 5th time the case had been before the Indian courts. So foreign entities may be concerned that their award will be subject to this 5th bite of the cherry and lead to lengthy and costly proceedings. But this fear of a potential chilling effect could be more impressionistic than real in real terms. Because first, the judgment does have to be taken on its own facts. It involved a state entity, and the Supreme Court itself acknowledged that this wasn't adopted as an ordinary course and has to be seen on its specific facts. Another point which I think is important is that this arbitration concerned a domestic award. And the section 34 sub 2 sub A of the Arbitration Act was in question, which states an arbitral award arising out of arbitrations other than international commercial arbitrations may be set aside if there's patent illegality appearing on the face of the award. So the decision is actually silent on international commercial arbitrations. And so while the Supreme Court didn't rule out interference of an award via the curative route of an international commercial arbitration, that wasn't this case. So while it might be accurate to say that the judgment has the potential to open the floodgates, the flood of curative petitions, particularly in relation to international commercial arbitrations, has not and may never come. And I mean, the flip side of this is that foreign entities may look at the judgment from another perspective. They can see that India is a court that expects high standards in terms of its arbitrators, in terms of reviewing evidence in infrastructure disputes, and will also take allegations of illegality seriously. So I think there's lots of ways for foreign entities to look at the judgment in this case.
Thank you, Hannah. That's a great and, dare say, refreshing perspective. Mr. Chauhan, you are an engineer and you're also overseeing several disputes. How does the judgment impact the role and responsibilities of in-house counsel when handling such cases?
Thank you, Adarsh and MRP. Your question regarding in-house counsels. See, we do a lot of homework before we go for any arbitration. That contemporary documents creation. Then whenever we feel that we are deprived of our due, what are the contractual dues, then only we go for arbitrations. Because government are most of the clients are government bodies only. More than 99% of the clients are government bodies. So even for our legitimate claims, due to government officials not taking right decisions during the course of performance of the contract, we had to invoke arbitrations. And the same mentality prevails, which was during the execution of the contracts. The same mentality prevails even after arbitration award is pronounced in the favor of contractor or the concessionaire. In this particular case, the DAMEPL is a concessionaire, and that was a termination payment. So even after arbitration awards are declared, we are not sure that we will get the money. Then we go for, client goes for section 34, 37, most of the times up to Supreme Court, and particularly in high value awards. Any award which is of high value, we are sure that case will go up to the Supreme Court unless in the meantime there is some provisions like this Vivad Se Vishwas scheme came into picture. So we had tried to settle most of our claims in this scheme itself, whether it is 65% after the arbitral award or 85% after the court award. So we prefer to go for settlement so that we get money and avoid the legal proceedings, which may go for 10 years, 15 years, anytime. And it is very difficult to realize money from the government departments. And this judgment in this particular case, this has opened a floodgate. Now everybody is certain to go up to invoking curative petition, whether Supreme Court admits it or not. But this is a thing which is going to delay further the finality of awards. So that is the case. And for the councils, councils do what they can. But I don't want to say that councils leave something unturned, getting the award in their favor. So I don't think there is any. Only thing the councils have to keep in this also in mind, that appreciation of evidence can be opened up at any point of time by the courts.
Yes, I agree with you, Mr. Chauhan. To what extent can counsel plan for overlooking, how they can ensure that the tribunal does not overlook vital evidence? I mean, once the arguments are done and the written submissions are filed, I suppose it's the tribunal's duty to make sure that it considers all evidence and does not overlook anything. And I agree with you. I mean, perhaps anecdotally also, I can also share that I have also noticed several PSUs, especially trying to go right up to the Supreme Court to see if they can set aside the award or try to beat down some of the claims that have been passed by the tribunal. But yes, I mean, something that Hannah had mentioned as well, Mehak, 68 hearings in the arbitration. We're talking about commercial operations in 2011 and an arbitration that started sometime in 2012 with the curative finally reaching its conclusion this summer. So we still don't have a final account for this project. So for commercial operations that have started in 2012 and termination that took place in 2012. I mean, it's going to be really hard for the legal counsel to now justify starting another arbitration. So do you see mediation playing a bigger role in preventing such disputes from escalating to the point of judicial intervention? You've seen how Mr. Chauhan tries to settle it by getting 65%, 85% once the court gives the judgment. What are your views on this?
So I think one aspect that I've already spoken about is those med-arb clauses that we're talking about. Those are very important. Second, I think the impetus that the government has now given to mediation, it is definitely going to help non-escalation to judicial intervention. One of the factors is if you see the Mediation Act that's come into play, the grounds for challenging the mediation, the settlement agreement, are very limited, which is just fraud, corruption, impersonation, and any kind of disputes which cannot be settled by mediation, which is like criminal disputes or something. So you cannot challenge it. And so that is one aspect that anyway de-escalates the judicial intervention. Second, mediation by the nature of its process itself, it gives a lot of party autonomy. So the parties have control over the process completely. So which also, because they get that kind of power, they automatically do not wish to go and escalate it to a judicial intervention. That is two. Then it also gives them the ability to be able to find very flexible and very creative solutions, which are again needed in these kind of projects because a lot of the times the customers are repetitive. It's a small industry. So you're looking at future pipelines with the same customers. So they are, the parties themselves are also cognizant of that fact. So flexible solutions is something parties are looking for, and therefore mediation, and therefore the reduction of judicial intervention. And expert mediators, trained mediators in their respective domains will also facilitate better mediation. And when there is a better facilitated mediation, more comprehensive settlement agreements, automatically the judicial intervention goes down. And I think last of all, like they say that, I mean, mediation says that if you want, you're more interested in proper ties versus proper teas, or you're looking at, short-term, are you looking at short-term gains or long-term benefits? So that's what you have to decide. So I think all these characteristics of mediation, if followed, will definitely lead to a lot of de-escalation of disputes as such.
Yeah, thank you, Mehak. That was helpful. Uma, I mean, a lot of these disputes and litigations are referred to as, bet the company litigations, especially in the US and UK. We're talking about more than 2,500 crore plus interest being awarded by the tribunal. And we all know that the DMRC's net operational income is only about 1/3 of that amount per year. So, I mean, do you think that an expert witness can especially in relation to quantum aspects. Do you think that an expert witness can do certain things to ensure that their testimony is robust and credible, considering that the Supreme Court has insisted that the contractual intent of the parties must be respected, and I suppose the amount would have also been weighing on their mind?
Yes, Adarsh, I've just heard your question. It is interesting what you just mentioned. But like I said, we as experts, we are going with the evidence that is before us, and we look at all the material facts and what we can, make out of that in light of the contractual provisions. So it's like a mix of both. We need to consider everything. And there are several gray areas. While you interpret the quantum issues, you still have an overlap with contractual provisions. Regardless of the amount, although we can give an opinion on that, at the end of the day, the expert has to look at what evidence is there and it has to align with the contract. For example, if the contractual, I had a dispute, I was involved in a dispute where there was a design issue and the contractor blames it as a design issue, whereas the employer says, no, it's poor workmanship. So you see, there are provisions under the contract which required certain criteria for the design. It was curtain walling, and the gaps should be of such a millimeter, something like that. And the contractor says, no, your design is faulty. It is not possible. There's thermal expansion. So you see, there are many provisions under the contract which come into play when you look at what is the value of the work done, or what is the cost involved. So as experts, we look at all the material facts. We stay within our area of expertise without coming to a conclusion. That is for the tribunal to decide. We only show the route and give them what we think is our view, and it is for them to decide based on all these interpretations, like you said. And sometimes there will be an opposing expert who gives a different opinion, but we try to align, we try to remove the discordant bits and agree on most of the issues. So that helps the tribunal to come to a narrower set of issues and closer to the core of the dispute. This is very important as experts because we are trying to help the tribunal to come to a decision. So I think I would hesitate to say that the conclusion should come from the expert, but we give opinion on what is our area of expertise and looking at all the material facts in an independent, objective way. That is the best assistance that we can give to the tribunal and to the parties.
Thank you, Uma. That certainly makes sense. Hannah, we know London is a very popular seat for arbitration, and we know several Indian parties opt for seats like London, which are renowned for minimal judicial intervention, for resolving their disputes. How can legal practitioners from countries such as England collaborate with their Indian counterparts to leverage the insights from this judgment and enhance cross-border cooperation?
Thank you, Adarsh. I've got three points on this question. First, there does seem to be a theme both in England and India of challenges to arbitration awards on the grounds of illegality and fraud. In the back end of 2023, in the case of Nigeria and P&ID, which we'll probably be most familiar with, Mr. Justice Robin Knowles, sitting in the English Commercial Court, found that Nigeria had established that the arbitration awards had been obtained by fraud and were contrary to public policy. So there is a difference with the Delhi Metro case, and that was to do with patent illegality rather than fraud per se. But I think we will globally probably see more attempted challenges on the grounds of perversity, illegality, and fraud. But it is one thing to raise it, and it's another thing to prove it successfully. And it does take the right case and the right facts. But I do think we will see this general trend of more attempted challenges. Second, I do think English practitioners can collaborate with Indian practitioners on such issues, particularly in terms of co-counselling and strategizing on the challenge of arbitration awards, for example, involving illegality. There may be arbitrations which involve English substantive law, but are substantively then seated in India. And that's where I really think the mix between the Indian and English team is beneficial. As I foreshadowed earlier, it's unclear to what extent the curated petition could be used in India-seated international commercial arbitrations. And that's something I'm sure we will all look forward to seeing or not seeing and watch this space. And third, as an arbitration practitioner, I do think this judgment gives us the chance to reflect on arbitration as a dispute resolution system more generally. My co-panelists have mentioned the doctrine of finality, and there is this question of how extensive should court supervision be of arbitration awards. And I think that question becomes even more finely balanced when involving state entities and allegations of illegality. And I think this is a very interesting central question that we should come back to as practitioners, particularly at a time when both England and India are reviewing their arbitration acts and considering potential amendments.
Thank you, Hannah. That was very insightful. Mr. Chauhan, just picking off from where Hannah left off, I mean, what are the proactive measures you can take to ensure compliance with some of these legal principles so that this is not repeated in any of your cases? I mean, we know that the Supreme Court has mentioned how the tribunal did not examine whether there were any effective steps to cure defects. If suppose you or your company rather were to terminate one of their ongoing contracts with the public sector undertaking, would you now be more careful about wording your termination letter more in view of this judgment? And would you be anticipating the defect curing time that is supposed to be taken?
Yeah. We have been in the same situation in one of our projects, and the process has just now started. Let's see what happens later on. But then what we have been trying to do is follow the procedure outlined in the contract verbatim. Whatever is there in the terms of cure period or notice period or whatever. So if there is a cure period of 90 days, so we try to allow them more than 90 days. Once the period of 90 days is over, sorry, we give them a reminder sort of thing, and then we go for, that's whatever the period defined in the contract, and then be very careful about the provisions of the agreement while going for termination. That is the one thing we have ensured. Sorry, and let me have water, please.
No problem, Mr. Chauhan. I'll just go on to Mehak for the time being. Mehak,
yeah. No.
Okay, you're back. Okay.
Yes. And you see the best recourse, as Mehak was also saying, that try to go for conciliation or mediation. Must try, because when we sign a settlement agreement during mediation process or conciliation process, that becomes binding. As for now, as on date, all the settlement agreements which are entered into by the employer and the contractor, they are upheld by the courts. There has been no single instance where settlement agreement has been signed and that has been overturned by the courts. At least to my knowledge, it is not there. So we also have been trying, even going out of the way to make the conciliation process a fruitful process and get the some result out of that settlement, so that we don't end up, because if you see this particular case, there has been 6 stages of this legal intervention or arbitration. Arbitration was in favor of DMAPL. Section 34 was in their favor. Then only Section 37 award was turned down. Then you see SLP as well as review petition. Supreme Court held that award is okay. Now, only at the curative stage, that's out of 6 stages, only 2 stages where this award was rejected. So you never know what is going to happen during the legal process. Whatever amount of, because everything, you become intelligent in the hindsight. So whenever an order comes, then you start thinking, I could have done this, I could have done that. But at the time of doing whatever evidence you are producing before the tribunal, when we are submitting our written submissions, and arbitral tribunal itself, they try to be very careful that they don't overstep any legal boundaries. The only after a court judgment comes, rejecting the award, then only we become more intelligent that we should not do this, we should not do that. So whenever, that is how the things are going in Indian judicial system, what at least a person of my stature cannot comment on that.
Nothing too much to lament about, Mr. Chauhan. Let's move to Ms. Mehak. Mehak, we had a question from the audience that I'm going to rephrase slightly. They want to know, several of them want to know what is going to be the impact of this judgment on pending Section 34s and Section 37s proceedings. Are the courts going to carry out a detailed scrutiny? I mean, one aspect of overlooking vital evidence is looking at evidence. So we had, are the courts going to now, for them to understand what vital evidence has been overlooked or whether it's been overlooked, there is going to be, especially in construction disputes, they'll have to look at a lot of evidence which goes against the principles of minimal judicial interventions. So yeah, and what are your views about pending Section 34 and 37 petitions in India?
So I would still like to be a little optimistic and say that this curative petition was an anomaly. And there has been a lot of flack also that has come out of it, where a lot of lawyers, a lot of people have said that you cannot encroach on the duties or the powers or the way the arbitrators conduct the arbitration. So, and if every single construction dispute goes this way, then India can forget about becoming the arbitration hub of the world. So as far as 34s and 37s are concerned, I feel that the courts are going to be even more careful, and they would have to have a rather robust and concrete reason for reappreciating the evidence. And I still think it will be a rare occurrence, especially in light of this curative petition, which has received a lot of flack.
Yeah, fair enough. Just rewinding the dispute resolution process a little bit more and going back to the points about mediation and negotiations. This is where I'm going to ask Uma as to what role she sees in claims consultants playing to prevent disputes from escalating to the point of such judicial intervention? Is there any role, Uma?
Yes, absolutely. I think the claims consultant's role is very crucial because they get involved in the project very early on. So they are on a live project. They have all the information right from the commencement of the project, in most cases, especially large projects. And they are involved in strategy, risk analysis. They know the works of the project. They have a handle on all issues. They are able to predict what could happen. What is they could foresee a lot of the issues that could go up into a dispute. So the role of the claims consultant is very significant, even when it goes to mediation, as what Mehak was saying, or even if it's conciliation or any other form of dispute resolution. The claims consultant's input would be very significant, and it would help the legal team as well as the parties. And a good and experienced claims consultant should stick their neck out and tell their client what are the pros and cons. And there is a difference between the claims consultant's role and that of the expert, because here you are actually uh, working on for the interests of your client. And you would try to avoid escalating the dispute to arbitration, or depending on what the client wants. Now, in the scenario where even if it goes to arbitration, all the information, the crucial information, is with the claims consultant, and the legal team can leverage that to include whatever is significant in the pleadings, and to even iron out issues like what we saw in the current case, the AMEL case, where they did not really address the effective steps clause which you mentioned. So there could be ways around that which the legal team can take up, because it is the role of the claims consultant to point out all those areas which are gray, and that is something only the claims consultant can do, because they are involved right from the beginning. And in some cases, a good consultant can also go on to be the independent expert if it goes on to arbitration, subject to the legal counsel instructing them separately for the role of testifying expert. And an experienced consultant knows the difference, because whatever they did as a consultant is privileged, and that's behind the wall. Once they become the independent expert, that's a different role. But they bring that wealth of information into whatever opinion that they give. And that is much appreciated by a tribunal or a judge who reviews that evidence. So I would think that claims consultant role is very important, especially in light of the judgment that I've just read about it. It is very significant.
Thank you, Uma. Thank you so much. Hannah, I'm just going to rephrase a question that the audience has sent across. And I'm going to preface it a little bit with some context. We know of several instances where institutions like the JICA has insisted on funding, or has insisted on a foreign seat of arbitration to be incorporated into the dispute resolution provision for all their investments, or most of their investments, in India. So, and we see more and more foreign based fund houses insisting that they have the arbitration seated abroad. Singapore is an attractive choice these days. There is, of course, Dubai, London, Geneva. Hong Kong remains another popular choice. With this judgment coming through, do you see parties now taking their arbitrations outside India?
Thank you, Adarsh. And just as commentary as well, the recent SIAC statistics, we can see that Indian parties are now one of the greatest users of SIAC. So it is a really interesting time, both for Indian parties and India as a seat of arbitration. As I alluded to, I think there is a general impression that foreign entities could now look to other seats more than India. But as I say, for the reasons I've given, I don't think there should be concern, because this was a domestic award involving a state entity and was on particular facts. And has had lots of scrutiny by practitioners in the arbitration world. So I am also optimistic with Mehak that this is, to an extent, a case on its own facts. However, what impression that will give to funders and foreign entities is a different question. So it may be that we see more of a move to SIAC London seats, but as I say, I don't personally feel that there is that concern unless we begin to see the flood of curated petitions affecting international commercial arbitrations. And whilst this judgment opens the potential for that, we're not there yet. So I think it's a bit of a red herring to think that this judgment will definitely encourage the use of other seats, although it may give the possibility of that.
Fair enough, Hannah. I think I agree with you. Mr. Chauhan, this is another interesting question from one of the audience members. This is mostly in relation to classic construction disputes rather than disputes arising out of concessionaire agreements. One of the audience members is asking, in a situation where contracts stipulate that project directors or project managers are authorized to take commercial decisions instead of disputing and taking it to DAB, the hypothesis is that there would be likely improvements in the dispute resolution processes. Do you think that is a possible solution?
The question pertains to DAB?
Yes, to take the project director's ability to take commercial decisions as opposed to insisting that all decisions be made by the DAB.
I understand that project director means particularly in the matters of NHA involving NHAI, the project directors are there. So project directors have got no authority whatsoever. So whatever that
I think it's the engineers in charge that they're talking about.
No, I will clarify because I'm involved in NHI matters a lot. So there is an engineer. Sometimes they are called independent engineer in case of PPP projects, and authority engineers in case of other contracts, EPC mode or whatever. So engineer's role is only to advise. As per agreement, the first point of dispute determination is the role of engineer. But as our minister has always said, the independent engineers are dependent engineers. So role of independent engineer is somewhat it has turned into the authorities person only. So whatever authority says, independent engineer or authority engineer says the same. So we never invoke that provision of resolution by the engineer. So we directly go to the authority. Authority means from project director up to chairman. So project director has got no authority whatsoever to implement the decision of DAB or arbitral tribunal or anyone. So it goes up to the level of executive council in NHAI. Once the executive council ratifies the decision taken by the DAB or other conciliating bodies, then only it is implemented. In some cases, NHAI has propounded that the committees it has formed, that is independent experts, conciliation committee of independent experts. The decisions of conciliation committee of independent experts, they has to be ratified by the EC. So whenever there is a decision by CCI, that is implemented. But then it's a conciliation process, and most of the time it fails. So that's how project director or project manager, they don't have any powers in NHAI.
Mehak, one of the audience members has asked a very difficult question according to me, and
Oh my.
I'm going to pose that for you. There isn't good. There will have to be an element of speculation when you answer this. But the question is, what prompted the judiciary to reverse this award? And there's a second part of this question. Can anyone just leverage the contract the way DMRC did to be able to succeed eventually?
Can you rephrase that?
Yeah, the question actually is, can anyone just leverage the contract the way DMRC did to get their objective?
Shouldn't be so. So like I said before, that's why contract drafting is very important. Like, we also in our contracts, the term that they're talking about, to either cure the defect or take effective steps within the X amount of period, it's very crucial. And there's a very specific reason that we write it. We write it because we know that it's such a large project. I do not know if I'll even be able to figure out the cure within the 30-day period. So that's why it's crafted in that manner. So that's why I said it's very important to have that legacy of documentation so that you're able to drill down on the actual intent of the clauses. So leveraging on bad drafting is a fate of the parties who did not negotiate it and write it well.
Fair enough.
I don't know if I managed to answer that.
No, that was difficult anyway, and I don't suppose it would be difficult for you to anyway answer what prompted the judiciary to reverse the award anyway. And
wow, that nobody can. I can't get into the heads of the Supreme Court judges, and I shouldn't also, as a matter of respect. So no, I'm not going to answer that one.
Yeah. That is
I
correct.
plead the fifth.
Now, one question for you. I mean, have there been illustrations of similar such judgments for patent illegality in the courts of England and Wales?
Thank you. And I think that's what makes this judgment actually so interesting, where it's 34 sub 2 sub A, and it's particularly in relation to domestic awards. My understanding is that's a fairly unique provision, and in England doesn't have a similar provision for domestic awards. So you won't find perversity or patent illegality as such. I do think anybody who's particularly interested in this topic should look at the Nigerian P&ID decision. It's a long decision, but it's incredibly interesting, and it has similar factors at play in that it involves state. It also involves lots and lots of evidence, public policy, considerations of fraud, and the concluding paragraph of Mr. Justice Robin Knowles sets out sort of considerations of arbitration users, of what arbitration should be and the standards that there should be in arbitration in terms of transparency and accountability. And I think it certainly pulls on similar themes. And I think it's so interesting that these judgments are timed at similar points. So whilst there isn't exactly the same type of judgment, I think that it's following a similar theme. But I do sort of a question. I've given many talks on Nigerian P&ID recently, and many people are now saying, can we advance challenges on fraud? Is it going to be easier? And it's not necessarily so. I think we might see a flurry of attempts, but whether they're successful or not, it really does take the right case to get it over the line. But we don't have a similar decision in the sense of it going to like a fifth stage of review. There's not something that's comparable in that sense. But I do think there's a global theme of illegality and fraud, and it will be interesting to see over the next couple of years whether the attempts off the back of these cases are successful, or if they're shut down in line with sort of the concluding remarks of the Supreme Court that said this is not the ordinary course. So we will see if it is or it isn't in practice.
Thank you so much, Hannah. Thank you, everyone. As we conclude our insightful discussion on the Supreme Court's judgment, we all agree that the judgment has significant implications for India's aspirations to become a top global arbitration destination. We also agree probably that it has a significant implication for legal practitioners and parties involved in arbitration proceedings in India. The Supreme Court's detailed analysis of the curative jurisdiction and the grounds for setting aside awards has provided some clarity on the scope of judicial intervention in arbitration matters. And I suppose the panel also acknowledged that there are practical implications of this ruling, particularly concerning the challenges that legal professionals are going to face in navigating the nuances of curative jurisdictions, inasmuch as it may create uncertainty or hesitation amongst parties considering India as an arbitration seat. If not addressed effectively, the judgment's emphasis on the court's ability to scrutinize awards for patent illegality or perversity could be perceived as an expansion of judicial intervention. And this may also deter foreign entities from choosing India for their arbitration proceedings. I suppose the panelists have also offered valuable insights on how in-house counsel and law firms must proactively align their practices with the legal principles and take on the role of negotiations and mediators to mitigate the risks associated with challenging arbitral awards. The panel also highlighted the increased scope for challenging awards under the curative jurisdiction could lead to prolonged disputes and delays in enforcement. And this could undermine the efficiency and reliability of the Indian arbitration system and potentially damaging the country's reputation as an arbitration-friendly jurisdiction. I suppose India must strike a careful balance between providing a robust legal framework and ensuring that the arbitration process remains efficient and predictable. Now, ongoing efforts to align domestic practices with the principles of this judgment, and while addressing the practical challenges being faced by legal professionals, will be crucial in solidifying India's appeal as a preferred destination. Thank you so much for everybody for joining this webinar. All of us really appreciate us joining and taking your time for viewing this webinar.
Thank you, Adarsh.
Thank you, Adarsh.
Thank you, everyone.
Thank you, Adarsh and MRP.
Thank you.